Back on September 29, 2003, I alerted this court. At that time, I told this court, I tremble at what I find myself faced with at this juncture. I have 9 children, and my wife and I expect a 10th next spring. I do not lightly put myself in a situation where, for all practical purposes, my means of supporting my family may be seriously jeopardized. But on the other hand, what has occurred in the above-captioned case is such an outrage of justice and common decency that my responsibility as an attorney for Adam Raisback and as a citizen compels me to act. There's no doubt that the director of this firm, be it your in-house law firm or be it something else, it is supervised by this court. And the director, without a doubt, fabricated. He falsified the most critical assertion against me. It was false. It can be easily shown as being false. It has been shown to you to have been false on numerous occasions. And yet this court did nothing. Did nothing, even though this court had to have known that his falsification would destroy my reputation, would destroy me financially.
You have represented as a fact that the Office of Lawyer Regulation is our in-house law firm. I think that is a totally inaccurate representation. The Office of Lawyer Regulation is an agency that prosecutes violation of the ethical rules, but by no stretch of the imagination, for me, is that our in-house law firm.
Well, Your Honor,
I can never get advice from them.
Well, Your Honor, I find that to be somewhat amusing, and I'm not trying to be disrespectful, because they characterize themselves as your in-house law firm in this case. That was quite some time ago. If that was your opinion, I would have thought you would have voiced it well before today. But that wasn't my characterization. That was their characterization in this very case, in a brief I know that you received. So I don't think it is at all unfair for me to have characterized them in that fashion. The first count against me was based upon an out-and-out falsification. There can be no doubt at this time that it was a falsification. The Office of Lawyer Regulation claimed to have found in Adam Raisback's court file a subpoena that had been served. Well, of course, as everybody knows, it has never been found. Even the Office of Lawyer Regulation concedes that at this point in time. But that's what set in motion me being charged. That's what set in motion the papers picking it up. That's what set in motion my reputation being destroyed, me being financially destroyed. It's interesting that Judge Prosser was so concerned about what takes place with CCAP, how people's reputations can be destroyed by false allegations to which they are later acquitted or the charges are dropped. But when it comes to me, this court has no concern. It has no concern whatsoever that that took place, and it was orchestrated by this court's very own in-house law firm and its director, something that cannot be honestly disputed by anyone. I find myself in front of a tribunal right now who's the son of one of these judges, Justice Crooks' son, has threatened me with being criminally charged, threatened me with civil action, threatened me that Oloar, to sic Oloar upon me. And for what? Just because I publicly informed the public on a radio show, honestly, on the Mitch Hank show, that Justice Bukowski had conceded under oath that the evidence is that Justice Crooks' son's client committed perjury, lied falsely, on behalf of the Dane County District Attorney's Office. Now, if I think for any fair-minded person, they would be concerned, they would be troubled. Isn't this a conflict of interest? But apparently, there is no concern from this court. We go forward. Everyone else, basically, any other, we have arguments that are in the paper about how this court is worried about this conflict of interest, that conflict of interest in regards to Justice Gableman, Justice Ziegler, who are not even here, apparently for some apparent conflict of interest, but I don't know what that could possibly be. But anyways, these justices are not here. But Justice Crooks is here. And how can that be? Because what took place in those 6 days of evidentiary hearing? What was testified to? One, Krenz testified. Before they commenced the prosecution, they knew the evidence that Humphrey was using was invalid and falsified. That's part of the testimony. Two, the statement that Krenz testified to on Humphrey's behalf was false. Krenz conceded he could not have truthfully said that. Three, Nasinski testified. They then came up with a second falsified analysis in the presence of him, Krenz, and Humphrey. Four, Nasinski testified. The photographic evidence that proved the whole thing was false. Humphrey literally told him to remove that photographic evidence from a deputy's locker, bring it to Krenz's office, and it was falsely represented in court that neither Nasinski nor Humphrey knew where the exculpatory evidence was. And five, Humphrey's own subordinate testified that the warrant, the affidavit to get the warrant on McCoy was false. Six, the detective testified that the statements that Oloar gave her, had put in her mouth in order to justify the allegation on count one, were not true. She never said those things. She never could have said those things. Those are the things that all came out at those evidentiary hearings. And when she says, I have an affirmative defense, my God, that sins against the light. I was told after 6 days of evidentiary hearings that the evidence didn't count, literally didn't count. All you have to do is look at the referee's order and decision. The name Krenz never comes up. The name Nasinski never comes up. He, as he said he would, he ignored it. It didn't count. That's what took place. To say that, that's like saying hey, you can play a baseball game, and if you win, we'll say you won. But all the runs that you score, they don't count. And besides that, of course, because of this court's particular rules, I got to pay for them, for the 6 days of evidentiary hearings that don't count. Due to this court's peculiar rules, I have to pay the referee for his time. I have to pay Oloar for their time. This court has stayed its own rules. Is that not a green light for Oloar to continue in the systematic dishonesty? As I told the court, that is what would occur, and that is what has occurred. It never stops, as I even showed in my reply brief, even up to this very moment. They make assertions that not only are false, but assertions they know that every single one of you knows it's false. Is it not reasonable to conclude that Oluwari would view the whole thing as, we got your back, Sommers has to go down, do whatever you can. We must discredit him because he is too much of a danger to what goes on and to what this court has permitted to go on. I believe any rational, fair-minded person would see it in such a way. And I don't know why, and I don't know by what authority you have to stay it. What right do they have to engage in systematic misconduct? What right do they have to engage in perjury? What right do they have to withhold documents and say, well, sometime down the road, we're going to deal with it? I don't think that's just, especially when you're talking about destroying a man's profession, destroying a man's reputation, wiping him out. This is a very intelligent court. This court knows what Oluwari has done. This court knows that that's why we have rules that are supposed to be put into place. And I do not understand, for the life of me, why they would be stayed to, basically, for the benefit of attorneys who, in this court's name, have been proven to engage in the most systematic dishonesty. I do not understand. But I did the best I could in light of all the criminal conduct and all the things that were taking place. And I came to this court. I pleaded with this court. I showed this court the state statute, but this court had the power to intervene. And this court did nothing. And instead, I found myself ruined, wiped out. Everything I did in that case was decent. I did the best I could, and I was honest. And yet this court, whether it's your in-house law firm, it's your firm that you control, you gave them a green light to wipe me out, to falsely accuse me, and they've done it. And they're going to get up here in a couple of minutes, and they're going to continue with outrageous false statements that what I did, I was trying to alert the public to something that was truly, gravely evil. It was immoral, it was evil. And the public needed to be aware. And to act like you can do something on appeal when you convict a young teenage boy through a fraudulent case, like somehow, well, we can fix it a few years later. As this court knows, as judge, as everybody here knows, appeals take a long time. I guess if he rotted in prison for a couple of years, well, we can all say then maybe he could have maybe then he could put his life together. It'd be a good learning, education experience. I didn't see it that way.